Hey, what's up everyone? Welcome to today's video. Trust me, you were in for a treat. We got an epic moment where a judge completely shuts down a defendant who's insisting on representing himself in court. Big thanks to Colin for catching this live and sharing it with me so I can bring it to you guys. But before we dive into the action, I need to quickly talk about today's sponsor, Aura. Now, I know I often bring up data breaches, but that's because they're happening all the time. Just last month, Bank of America exposed tons of personal data, names, account details, social security numbers, even government IDs because documents were carelessly left out in an unsecured container. And get this happened back in December 2024, but it's just being reported now. According to IBM, it takes an average of 277 days for companies to even report breaches. That means your info could have been circulating on the dark web for months before you even knew. And this isn't the first time Bank of America has had an issue. Citigroup and JP Morgan Chase both had breaches last year too. Your bank could be next, and you might not find out until months later. So here's the real question. Do you really want criminals to have a head start with your personal info? That's why I'm proud to partner with Aura. Aura instantly alerts me if my personal info, mail, phone number, social security number shows up on the dark web. They even notify me if someone tries to use it to access my accounts. And if the worst happens, they offer $5 million in identity theft insurance. Don't leave your personal info vulnerable. Sign up for Aura and get a 14-day free trial by visiting Aura.com. Team Skeptic. Big thanks to Aura for sponsoring today's video. Now let's get to the good stuff.
All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right.
Okay.
Just a minute. Be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not. I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
Well, it's hard to give a clear answer when you're basically working with a mouthful of crayons.
So, Mr. Taylor, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process, this process here, this pretrial hearing, I got motions. I like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake. And you haven't asked for that, and there's you be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient, listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point, is that there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions that based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yep.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today, so if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I want to ask to have my attorney removed. I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV. This is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws. I got
motion. What kind of motions are you talking about, Mr. Taylor?
Well, one is a motion to suppress. I got one here. It's
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be.
He might be able to answer if you frame the question in a way he understands better. But since you're using standard English and he hasn't had his daily fix, there's a serious disconnect.
I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file the motion.
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
That's on my paperwork here. None of you organized here at the same time.
So you have an answer. What is it you would seek to suppress? Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait, I'm having trouble understanding you. I can hear you.
I'd like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, They're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds, man. I haven't.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm be respectful. Wait till you're done talking.
I'm sorry, what?
Don't be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay, I asked you to answer my question, and you didn't. When I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, it ain't gonna make you a lawyer.
I don't know where this judge has been all my life, but I'm so glad Colin found him for us. It's rare to see a judge who calls it like he sees it, and right now he's staring at someone who's like an idiot save it without the stavant part.
Represent myself.
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand your mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm undiscovered. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, my understanding, he's given you more than what most defendants get in these kind of cases because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so I don't know what you're talking about when you say you don't have discovery because you've got everything that he...
Well, he's got everything except a law degree and his freedom, but sure, he's got all the documents his lawyer would have had.
And that's it. Discovery is he's giving you what he has.
My discoveries don't even have counsel. I've only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And same time, I get a piece. I get a piece 1 week. I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to trial. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. With the court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
My percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
He said his percentage would be higher. His percentage of winning would be higher if he
Oh, yeah? What do you think that would be?
I don't know.
Well, give me the odds, and I'll take that bet. Because you're absolutely 100% wrong. You know, everything you're saying here is exposing the stupidity of your position. And for me to allow you to represent yourself will be guaranteeing you a conviction. You'd be getting convicted of everything. You don't know what you're talking about.
This guy's in serious trouble and he can't even answer basic questions to build a defense. And somehow in his mind, this is what improving his odds looks like. At this point, I just point him to a tree and let him play hang the defendant by himself.
What deer means? Okay. Yeah, do you know what the separation of witnesses is?
That's one of my motions. Motion to seven.
Well, we don't get, no, separation of witnesses, I ask you.
Yes, yes.
What is, okay. So what is it?
Ask 5.
Huh?
Motion to ask him to 5.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, you know, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You know, you should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file. Again, you cannot. Pardon me?
You got a list here.
What?
I think he's basing his list off of other people.
No, I'm not.
Because he thinks there's a set. No, sir. He thinks
Listen, be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. No, would like to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you to understand it, right?
Yes, he showed me the digital stuff, but he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
Cross-examination would be based upon their report.
Also, the submission report to the PCI lab I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from there.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it.
That doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
he
well,
has
there would
the
be.
CI's. Yeah. He has the CI's criminal history. He just doesn't know how to read the discovery.
You could have just stopped at the word read, and honestly, at this point, I'd be shocked if he could even read the ingredient label on a bottle of table salt.